information presentation for family daycare services across Australia. My name is Nikki Spalding and I'm presenting this session on behalf of the Family Daycare Services Education and Support Project. As at the 13th of March 2017, the Australian Government brought in changes to the Family Assistance Law to strengthen the integrity of the childcare payments compliance framework, or in other words, reduce the likelihood of serious non-compliance and potential fraud in the family daycare sector. The changes affect all family daycare services and may require some changes to your own services, policies and procedures. This webinar will explain what the changes are, what the government is trying to achieve, and what changes your service may have to make as a consequence. As we are unable to offer you a question and answer option within this information webinar, you will find you can access a printable handout version of the presentation at the end of the session. Any questions regarding your particular service should also be referred to childcareintegrity@education.gov.au. This address will appear on a later slide. Also, in the event that you experience technical difficulties, a recording of this presentation will be uploaded onto our Education and Support website and made available for you to access after the 3 webinars have been delivered later this week. Therefore, you can check next week on the Support Project website, www.fdcsupport.org.au. The latest update regarding the new childcare package. From July the 2nd, 2018, Australia will have a new childcare package, including the new childcare subsidy. The subsidy will replace the childcare benefit and childcare rebate. Information for families and providers about the new package, as well as the current arrangements, is now available at education.gov.au/childcare. An information page on transitioning to the new childcare package will always have the latest details about the transition process, so we encourage you to check it regularly. This page is available at education.gov.au/transitioning new childcare package. Over the next 12 months, the Department of Education and Training website will be updated regularly with the information, which will help answer your questions, as well as any questions your families may have about their transition to the childcare subsidy. So what is the Family Assistance Law? That is, until the 1st of July 2018. The Family Assistance Law is the basis for Commonwealth childcare fee assistance, which currently includes childcare benefit and childcare rebate. Under the Family Assistance Law, your family daycare service is approved to administer childcare fee assistance on behalf of eligible families. More information regarding the current childcare legislation and the updates for the new childcare package is available at education.gov.au/ECCC. Under the current childcare legislation, and this is until the 1st of July 2018, your service is approved to operate for the purposes of receiving the current childcare benefit and childcare rebate payments on behalf of eligible families under the Family Assistance Law. The Family Assistance Laws from the 13th of March 2017. There are 3 main changes. One is regarding older children changes. The second, maximum hourly amount of $12.84 per hour for grandparent childcare benefit and special childcare benefit. The third is in regard to additional child swapping changes. So, the first, family daycare services can no longer receive childcare subsidies on behalf of families for children who are at secondary school or 14 years or over, unless they cannot reasonably be left alone and there's no other adult to look after them, and a specified circumstance applies. In regards to the second, childcare provided by an approved family daycare service is not a session of care. For grandparent childcare benefit and special childcare benefit purposes, where the reported fees involve amounts for which no individual has incurred a genuine liability, or the reported fees exceed the maximum hourly rate of $12.84 per hour. In regard to the third, there are additional changes to tighten up evidentiary requirements and the work and study exemptions to the child swapping rules that initially started on the 12th of October 2015. So what happens if you do not comply? There are serious penalties if family daycare services do not comply with their obligations. The penalties range from debt recovery action, financial penalties to sanctions, the immediate suspension or cancellation of childcare benefit approval, or criminal investigation and prosecution. Complying with family assistance law is mandatory, and there are serious penalties if you do not comply with your obligations. These penalties range from debt recovery action and fines to sanctions, such as the immediate suspension or cancellation of your childcare benefit approval, or criminal investigation and prosecution. We will now further investigate the older children changes. So why were these changes made? The government is concerned about serious non-compliance and potential fraud by some services. It has taken a range of actions to address non-compliance. In 2015 to 2016, childcare subsidies were paid for approximately 27,800 children aged 14 years or over, most of whom were in family daycare, and this related to 23,000. About 98% of childcare subsidy provided to children 14 years of over went to approved family daycare services. In 2015 to 16, the average attendance for a child in family daycare who had already turned 14 was 43 hours per week, while the average attendance for a child across family daycare was 32.5 hours. In long daycare, the average attendance is 28 hours per week. There is concern that some services are exploiting the subsidies for older children. There are no childcare subsidies for family daycare provided to adults, that is, people who have turned 18, children 14 years or over, or children attending secondary school, unless a specified circumstance applies. The government has determined that no one is eligible for childcare subsidies for family daycare provided to individuals who have turned 18 years of age, in other words, to adults. Also, no one is eligible for childcare subsidies for family daycare provided to a child who is 14 years or over who attends secondary school unless they cannot reasonably be left alone and there's no other adult to look after them, and a specified circumstance applies. There are specified circumstances where childcare subsidies may be available for children in secondary school or 14 years or over. For example, where a child has a disability or is being diagnosed, or the child lives in a remote or very remote area. We will go through these circumstances in the next slides. For most family daycare services, and most children however, subsidies will no longer be given to children 14 years or over or children attending secondary school. Family daycare services are required to have received documentary evidence and a statutory declaration from the parent. Services must download and use a register of specified circumstances when they are caring for an older child. Family daycare services can still provide care. The legislation does not say services cannot provide care to children 14 or over or children attending secondary school. The family can no longer receive childcare subsidies for that care unless the child cannot reasonably be left alone and there is no other adult to look after them, and a specified circumstance applies. Where a session of care is provided to a child and they are not eligible for childcare subsidies, family daycare services may provide care to the child and charge the family a fee, but must record the session of care in the Child Care Management System, that's CCMS, using a zero fee session type. So when do specified circumstances apply? These specified circumstances apply when an older child needs to be cared for in a family daycare service because they cannot reasonably be left alone and no adult can provide suitable care in the circumstances. The family daycare service must have documentary evidence in the form of a statutory declaration setting out the reasons why the child cannot reasonably have been left alone in the circumstances, and why there is no individual over the age of 18 who could have provided suitable care to the child in those circumstances. The three specified circumstances. There are three specified circumstances where a family can receive childcare subsidies for their older child attending family daycare. These are when an older child needs to be cared for in family daycare because the child has a disability or is being diagnosed, lives in a remote or very remote area, is under 16, and the parents or guardians have to work in a minimum of 5 hours on the care day, but this is not for an approved family daycare service. So in other words, the work would be outside of family daycare. In relation to older children with a disability, the child must be diagnosed with a disability or undergoing assessment for a disability. Documentary evidence must be provided to the family daycare service. If the child is 14 or over, or in secondary school, and cannot reasonably be left alone, and no adult can provide suitable care, and is either diagnosed with a disability or does not yet have a diagnosis but is undergoing assessment of disability, and the family daycare service is receiving the Inclusion Development Fund, IDF, the family daycare top-up under the Inclusion Support Program for the child, they are assessed as if they have a disability. The family can claim childcare subsidies but must provide documentary evidence to their family daycare service. There is a list of eligible disabilities or medical conditions which are listed in the legislation at Schedule 1 and 2 of the No One is Eligible determination found at www.legislation.gov.au/details. Circumstance 2 regards older children living in remote or very remote areas. Families can claim childcare subsidies must provide documentary evidence to their family daycare service showing the child's residential address. The definition of remote or very remote is determined by the Australian Statistical Geography Standard, Volume 5, Remoteness Structure, July 2013. If you Google ASGS and go onto the ABS website and look at remoteness structure, you will find the appropriate list. You can also check whether or not a child lives in a remote or very remote area at www.doctorconnect.gov.au. Areas that are classified as remote are identified as MMM6, and areas classified as very remote are identified as MMM7. Circumstance 3 is regarding older children of parents who have to work. This refers to children under 16 and the sole parent or both parents or guardians have to work for a minimum of 5 hours on the care day. Documentary evidence must be provided to the family day care service showing their usual hours of work. Where a child is 14 or over, or at secondary school, but is under 16, and both parents or parent and guardian or guardians are a sole parent, are required to work for a minimum of 5 hours on that care day, but this is not within an approved family day care service. In summary, you can only receive childcare subsidies on behalf of families for a child who is 14 or over or in secondary school in 3 specified areas, including disability, remoteness, or where the parent or guardians have to work a minimum of 5 hours on the care day. Documentary evidence must be provided. These 3 specified circumstances only apply when a child needs to be cared for in a family daycare service because they cannot reasonably be left alone and no adult can provide suitable care in the circumstances. So, what you have to do. Obtain a statutory declaration from the parent saying why the older child cannot be left alone and that no adult can provide care. Obtain documentary evidence of the circumstance. Keep a register of specified circumstances for older children. This can be downloaded from www.docs.education.gov.au. Documentary evidence must be received within 7 days after enrolment is confirmed, or no later than the end of the 2nd week after the care was provided. Family daycare services must receive and keep evidence of the specified circumstances in a special register of specified circumstances for older children. You can download this from the Australian Government Department of Education and Training website at docs.education.gov.au. Where the parent is claiming childcare subsidies for a child 14 or over or in secondary school, family daycare services must obtain a statutory declaration from the parent saying why the child cannot be left alone and that there is no adult who could care for the child. You will need to get this from the parent no more than 7 days after the care has been provided. A statutory declaration form can be downloaded from the internet. Use the Commonwealth Statutory Declaration form instead of the state government form. Note, the statutory declaration needs to be witnessed by specified classes of people, such as lawyers, nurses, bankers. These are also listed on the form. In addition, family daycare services will need to have documentary evidence to demonstrate each specified circumstance. For example, a letter or certificate from a medical practitioner, evidence the service is receiving inclusion support program funding, residential address for a remote area child, and employment evidence showing the usual hours of work. Where the specified circumstance is ongoing, the evidence only needs to be provided once in relation to each request. However, if circumstances change, fresh documentary evidence is required within the timeframes. This information again relates to the documentary evidence. The register requires family daycare services to receive and keep the name, customer reference number, which of the exemptions apply, etc., as well as the information that's included in the slide. The first is in relation to the child as an eligible disability child. A letter or certificate from a qualified medical practitioner or registered psychologist containing the child's name and date of birth, the name of the diagnosed condition, and the date of the diagnosis. The diagnosis must have been obtained no more than 2 years before the evidence is given to the service. The child is an eligible inclusion support program child, ISP. Documentary evidence that the approved family daycare service is receiving ISP because the child is undergoing assessment of disability. Approved family daycare services will already have this evidence. The child is a remote area child. A copy of the eligible individual's current driver's licence or a recent utility bill sent to the address where the individual or child reside, or a statutory declaration stating the child's residential address. Family daycare services can check whether or not a child lives in a remote or very remote area at drconnect.gov.au. Areas that are classified as remote or identified as MMM6 or very remote, again, are identified as MMM7. Work. An employment contract or payslip showing usual hours of work. If the documents do not show usual hours of work, a letter signed by the relevant employer stating the individual's usual hours of work. We will now look at the information regarding maximum hourly amount for GCCB and SCCB. This relates, of course, to grandparent childcare benefit and special childcare benefit. In the quarter leading to January 2015, government expenditure for grandparent childcare benefit in family daycare was less than $10 million. By September 2016, it had grown to approximately $40 million. Some family daycare services have been claiming inflated fees for grandparent childcare benefit and special childcare benefit because the government currently pays 100% of fees for these two subsidies. Sorry, I'm gone there. The maximum hourly amount. Family daycare services must not report sessions of care for GCCB and SCCB where no individual has incurred a genuine liability for the care, or the reported fees exceed the maximum amount of $12.84 per hour. For most family daycare services, these changes will not be an issue, as they already ensure that a genuine liability has been incurred for the childcare, and the fees they report for grandparent childcare benefit and special childcare benefit do not exceed what they would charge for other sessions of care. So what is genuine liability? An individual is only eligible for childcare fee assistance where a service imposes a liability on an individual by charging a real commercial fee for that care. A liability to pay that fee must already have been incurred, irrespective of whether any childcare payment is subsequently made by the government to reduce some or all of that liability. That is, the arrangement between the service and the individual must be one that is commercial in nature and requires the payment of fees in return for childcare. Care for which there is no fee liability incurred by any individual is not childcare of the kind that childcare assistance was established to subsidise. Approved services must not provide attendance reports for childcare fee assistance on behalf of families for care where the service has not charged a real commercial fee for that care. In addition, families will not be able to claim grandparent childcare benefit or special childcare benefit, and family daycare services will not be able to claim special childcare benefit where a genuine liability has not been incurred or the reported fees are higher than $12.84 per hour. Approved family daycare services must not submit attendance reports for childcare fee assistance on behalf of families for care that is not a session of care. Care is not a session of care when the reported fees exceed the maximum amount of $12.84 per hour. Services may charge the family a fee for the service, but must not record the care in the Childcare Management System, CCMS. If your standard fees are genuinely higher than this amount, you can make an application to the Department of Education and Training for a higher amount. Making an application. Approved family daycare services that genuinely charge fees above the maximum amount for grandparent childcare benefit or special childcare benefit can apply for the department to consider a higher amount. Information and guidance on the application process is available at education.gov.au/compliance. The application form is also available at docs.education.gov.au. Some important points to remember. Services should only claim for GCCB or SCCB if an individual has incurred a genuine liability for the fee, and if the service does not inflate the fees over the usual fees if the GCCB or the SCCB rate did not apply. Service providers are instructed to not falsely report or inflate fees for either GCCB or SCCB. In summary, the maximum hourly amount of $12.84 per hour applies for grandparent childcare benefit and special childcare benefit. The third point here relates to new child swapping changes. So we will look at these in relation to changes to band fee assistance for child swapping in family daycare, which commenced in October 2015. Child swapping changes. In relation to specified circumstances, it is only for formal program study at Certificate 3 or above level as part of a formal timetable provided by a registered training organisation on the same day that the care takes place, such as attending a lecture or undertaking an exam, which is only scheduled at a certain time. Therefore, it is not just I'm studying for Certificate 3 today. The requirement for evidence of an education or work exemption is clearer. These must show that the session of care actually overlaps or conflicts with the study or work, and services must receive evidence of a specified circumstance within set time frames. The government has strengthened the child swapping integrity measures that commenced the 12th of October 2015. The term engaged in activities for the purpose of the program reflects the intent that specified circumstances provides for formal programmed educational activities only at Certificate 3 or above, which are outside the control of the family daycare educator. The requirement for evidence of education or work exemption to establish whether the session of care overlaps or conflicts with the study or work, and that's to be clarified. Approved family daycare services must have evidence of a specified circumstance within the timeframes that they must report the session of care in the Childcare Management System, CCMS. Caring for children of a family daycare educator. Services should download a new register of specified circumstances for child swapping. This can be done at docs.education.gov.au. If your service provides care for family daycare educators on the same day that they provide family daycare, you need to download this new register. Documentary evidence must be received within 7 days after enrolment is confirmed, or no later than the end of the second week after the care is provided. This register explains the requirements in more detail, but essentially you will need to ensure the educator is actually required to be at a formal program study at Certificate 3 level or above, or actually working on the same day that the care is provided. So, where can service providers find more information? There is a form available to apply for a higher maximum amount for GCCB and or SCCB. New registers of documentary evidence for specified circumstances for older children and child swapping are available at education.gov.au/compliance or at familydaycaresupport.org.au. You can find more information on the Australian Government Department of Education and Training website. This is where the form and registers you may need to fill out can be downloaded from. And we will just remind you that the PowerPoint from this presentation will be available to you on the Family Daycare Support, Education and Support website from next week on if you did want to access it. So in relation to legislation changes, further information can be found. Childcare Benefits Session of Care Amendment Determination 2017. There's also information regarding childcare benefit children in respect of whom no one is eligible, Amendment Determination 2017. Eligibility of childcare services for approval and continued approval Amendment Determination 2017, and Record Keeping Amendment Rules 2017. If you have questions, we encourage you to email the Australian Government Department of Education and Training, childcare integrity at education.gov.au. It is better to ask questions now so that you do not risk the consequences of non-compliance with the Family Assistance Law. This slide shows where you can gain, where you can access information through the Family Daycare Education and Support Project. The email address is info@fdcsupport.org.au. The Sydney phone number is 0297799926. The project is managed by New South Wales Family Daycare Association and funded by the Australian Government Department of Education and Training. We thank you very much for your participation in the webinar today. Again, we'll remind you that the handouts will be available for you to download, and we do encourage you to keep abreast of current information through the websites that have been provided to you today. Thank you.